A unanimous Supreme Court decision this week protects thousands of delivery workers from being forced into secret arbitration proceedings, even when they never leave their home state. The ruling could reshape how companies handle disputes with the workers who get packages to your door. Nine Robes uses nonpartisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided. It's about why those decisions matter. To give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. Angelo Brock delivers Flowers Foods products around Colorado. He never crosses state lines, but the company tried to force him into private arbitration using a clause buried in his contract when he sued over being underpaid. Brock fought back, arguing that federal law protects transportation workers from forced arbitration. The Supreme Court agreed, unanimously. The key insight: Brock's deliveries were the final step in a journey that began in out-of-state bakeries. Even though his wheels never left Colorado, he was moving goods across state lines. That made him protected under a 1925 federal law designed to shield workers from losing their right to sue in court. Flowers Foods wanted a simple rule. Only workers who personally cross state lines or handle vehicles from other states deserve protection. The company argued this would be cleaner and easier for courts to apply. Justice Gorsuch rejected that argument for the entire court. He looked at what interstate commerce meant a century ago and found it included the final leg of a journey, even if that leg stayed within one state. He used a helpful example. Imagine 3 drivers each handling one segment of a snack delivery, with one crossing the state border. Under Flowers' logic, only that middle driver would be protected. The court said that makes no sense. All 3 drivers play a direct, necessary role in the same interstate journey. The court also drew on an old case about a steamboat that operated entirely within Michigan, but still counted as part of interstate commerce because it carried goods from other states. The message was clear: the last mile matters. Here's where things get complicated. Flowers Foods raised 2 other arguments that the court simply refused to address. First, that Brock runs his own company rather than working as an employee. Second, that he actually buys the products before reselling them, making him a merchant rather than a transportation worker. Courts across the country are split on both questions. Some say the federal protection only applies to individual workers, not small business owners. Others disagree. Some courts say if you take ownership of goods, you are a buyer and seller, not a transportation worker. Others say that does not matter. The Supreme Court punted on these issues, which means lower courts will have to figure them out case by case. For the modern economy, that is significant. Companies relying on last-mile delivery workers, a massive and growing part of how goods reach consumers, cannot assume their arbitration clauses will hold up just because workers stay in one state. Each situation will be different. Arbitration clauses are designed to keep disputes private and out of court. Workers often lose their right to sue publicly, to appeal, or to join class action lawsuits with coworkers facing the same problem. This decision says that federal law protects at least some delivery workers from that fate. The ruling is unanimous. Every justice agreed that workers moving goods across state lines deserve protection even if their own route never crosses a border. That suggests the court sees this as a straightforward application of a century-old law, not a close call. The practical reality is that millions of delivery workers keep the American economy moving. The Supreme Court has now said that companies cannot simply bury arbitration clauses in contracts and assume they will stick. Whether those clauses are enforceable will depend on the specific facts of each worker's job. That uncertainty may push some companies to negotiate rather than litigate, and it gives workers leverage to have their day in court. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.